payroll provider for vacation and PTO and make sure that you've got it set up that vacation's separate and sick days are separate and they just track separately, because it is a pain to do it yourself. Could you? Yes, you could with Excel sheets and everything, but why? Because already taking out the right taxes and Social Security and all of that is pretty challenging. And so if you have a payroll provider doing that anyway, then it's really easy to track sick and PTO.
I'm so tired of micromanaging. How do I train, manage, and lead? I can't find time to be visionary. Head down in the weeds.
All right, legal leaders, welcome back to another episode. I am so excited to have Peak One Law here today and the founder, Danielle Maya, with us to talk about some real threats to your business. And we're going to be talking about some tough decisions in regards to the legalese, the employment stuff, the people piece that I'm always talking about, and that I know I hear from attorneys all the time. Business would be great, but for the employees, the people piece. So Danielle, thank you for being here today.
Thank you, Molly.
Yes.
To be a part of this.
So tell everyone a little bit about, the saying, there's riches and niches, if you will, and you have a very unique practice and a very comprehensive approach to business law, employment law, in addition to estate planning with a concentration and contractors and construction. So give everyone a little bit of background on your why and really led you to your niche.
Absolutely. So I kind of started in Colorado about 8 years ago. I came from Texas. I had 18 years experience in Texas and working with contractors and trying to keep them out of litigation, did some construction defect, but really started building my practice on let's get preventative. I saw what happens when it goes wrong. And so let's get preventative. So, started adding kind of contracts and then corporate formation and now bringing in kind of estate planning. And my focus is really on small businesses, primarily in the construction area, but working with clients that I really like. And it's a long-term ongoing relationship to really be a business partner for them and keep them protected. And that starts with operational documents. But one thing that I noticed is that sometimes you would get a really great operating agreement, but it didn't necessarily tie to the estate plan. And people weren't transferring their interest in their business to the revocable living trust, which is a really important kind of link to do. And so I decided to really lean into estate planning and put that piece together because it wasn't really coming together for my clients when I was referring out. And so taking more of the comprehensive approach for small business owners has really seemed to resonate with my clients, and it really gives me fulfillment because I'm really able to give them the full package.
I love you said something really important that most solo practitioners, boutique law firms, small businesses don't really pay attention to. And you said clients that you like. And you're working in construction, right? You're working with contractors. My 24-year-old son has a degree in construction management and engineering from up at CSU. He's working for a big company that does heavy civil and concrete work, what have you. So I hear the horror stories every single day in regards to that. But tell our listeners a little bit about how clear and discerning you get with what you like, clients that you like, because you're in a really gritty industry. Like they, talk like truck drivers and high voltage, high stress, high energy. And you're so calm. When I first met you at the Colorado Bar Association, just like you're just so calm, and it's like polar opposites. So let's talk a little bit about clients that you like and why you like this type of industry.
Absolutely. Construction can have clients that sometimes talk like sailors and keep it exciting. But for me, it's really, there's great contractors out there and there's not so good contractors out there. And contractors that are kind of committed to doing the right thing and taking, having a good contract in place, having good systems in place to protect them. But ultimately, when there's a complaint, if something goes wrong, something always goes wrong on a job.
Yeah.
The first thing that they do is step in and say, hey, how can we resolve this? Yeah, we see that we messed up here. Let's move forward, and here's a plan. If they have a counterparty who's not open to that and is just litigious, then we've got the good structure in place to kind of push our issues. And whether it's with mechanics liens or what have you, we can make sure that they're protected. But I have found that I work well with clients that have that kind of mindset, that I'm gonna be proud of what I do, and I'm gonna do the best that I can. And if something goes wrong, I'll try to fix it. And so, I don't always get those kind of clients, but when I don't get those kind of clients, we don't work together very long. And so I'm fortunate enough that I have more work than I can do. And so if for some reason a client is not following my advice, I don't have any qualms about saying, you know what, this isn't a really good fit. Maybe you should try these other lawyers and give them a good recommendation. I'm also getting a lot better at screening on the front end. And it's not that it's so, that there's a perfect question to ask, but when you're having that dialogue with somebody, you can kind of pick up on some of those red flags. And when you're getting those red flags, and I tell this to my clients too, when they're vetting clients, you need to vet your clients, right?
Mm.
And not just work for anybody. And especially when the money looks like it's going to be really great on a job, there's no amount of money that should make you want to work with a client that you're getting red flags from. And every single litigation that I've been involved with that has gone really south, it's usually because somebody said, oh, it just looked like such a good deal. I couldn't turn it down, but I was getting those red flags and I knew I shouldn't do it. And I was like, yeah, don't do it. Walk away.
I love you said two powerful things. There's not necessarily an ideal script that you can follow, whether it's your intake team or what have you, that you just have to be really present and pay attention. Are they willing to listen to your counsel, which is what they're hiring you for? Or are they going to be incredibly combative and maybe egotistical and really fight you? How we do one thing is how we do everything up in the beginning of the process. And so, and if you find some red flags, if you will, throughout the process early on, you did your best on the intake, and then you find, oh, they're not going to be a great fit. I love that you're giving them this gift, right? You're even teaching them this is how they should screen clients. Don't be seduced by the money. Don't be
No,
seduced by the opportunity, but it's a two-sided relationship. Yes, there's legal contracts. Yes, there's all of that in place, but we all know this, that, people will die in legal fees just because their ego's in the front seat, right?
absolutely. And that also comes up too, even with some of my lovely clients that I've been working with for a long time. We have the good strategy in place, but every now and then they decide to kind of do that one-off project, and they decide to do a contract that's somebody else's contract that might not even have attorney's fees in it, right? And I'm like, why did you do this? And they go, well, I know, but it seemed like it was fine. It was just $50,000, and I'm like, yeah, it's just $50,000, right? And so, hopefully they, I've trained them enough, and they come to me. Well, we still have mechanics lien, and we can kind of work through that. But even if that hasn't happened, we have hard talks. Even when they have a great contract, they're owed the money, they have a good attorney's fee provision. Do you really want to go through litigation because you have the money, you can afford it? Yes, but especially for some of my clients who have never done it, they don't understand what a drain it is. They can't just turn it over to me and say, okay, go sue them, go after them. They're going to have to be a part of that process. And every single time I reach out to them and say, hey, let's go over discovery. Hey, let's prepare you for your deposition. Hey, let's prepare you for trial. That's going to take a toll on them.
Yes.
And it takes all of the positive energy. They're going to get upset about it because it's over something that's owed to them, right? It's a wrong that was done to them. And that's never fun to think about. And so, they can go and make more money. So my advice usually is, hey, I realize that that you feel like you've been wronged, and you have, but can you take this and learn from it and just go out there and make more money? Or do you really want to prove a point? And we can prove a point. I will do that if you want to do that. But you just, since you haven't done it, you don't understand the negative energy, the sleepless nights. You're going to wake up going, I can't believe I'm still dealing with this. And there's a cost to that.
And what beautiful counsel, especially, you'd be like, oh, litigation, I can just rack up the hourly rate. And I love that you come from that compassion driven counsel to say, can we shift this energy and go get one more client that's probably going to have a 4x, 2x, 3x ROI on it? But not only that, let's put our energy into prevention going forward. And this really brings me into today's topic. I'm going to put the link in the show notes, gang, for you all. But this phenomenal, I was reading this last night and I was like, wow, a blog that you have, Lessons from the Legal Trenches, 5 Tough Calls. And I'll highlight them really quickly, but one that stands out to me that I want to talk about today. Number 1, a verbal agreement that went silent. Number 2, a bad review that hit harder than a lawsuit. I love that one. We talk about Google reviews all the time. And I love that you say a Google rating is almost as valuable as your license. Number 3, an employee who was just a 1099 until he wasn't. 4 is an LLC that doesn't actually protect anything. And then 5 is a handbook can create a lawsuit when it's supposed to protect. And that's the one I want to hit today because I hear this all the time from entrepreneurs, attorneys, even in particular, in regards to a handbook that they maybe created in 1980 and it's been sitting on a shelf, or they got it off of their Facebook group of a bunch of attorneys that they hang out with, or even worse, that they just delegated it to AI and a virtual assistant to just slap together. So let's talk about this in your experience in regards as you service in-house counsel. You, in addition, work with small business owners. Talk to us a little bit about this employee manual that I don't think people talk about other than you need to have one.
Sure. I'd almost rather you not have one than have one that hasn't been put together right, because that's the thing that you're going to get stuck with when you go up against any discrimination claim, any wage and hour claim, any lawsuit about employment, right? They're going to really throw your employee handbook in your face. And if you can't stand up and say, yeah, we follow this policy, yeah, we follow this policy, it's the standard. The law doesn't create for you, right? A standard in terms of vacation, let's say, right? In Colorado, fortunately. So Colorado, let me just back up just a tiny bit, but Colorado has kind of gotten almost as progressive and employee friendly as California. And so you have to know as an employer in Colorado that there's just a ton of protections out there. However, they haven't gone so far as to dictate that you have to give vacation. And so if you're giving vacation, that's something that's free and wonderful and great. But you have to make sure you're doing it the right way, because this is where it can burn you badly. In Colorado, if you're giving vacation, it needs to be called vacation and not PTO, because PTO can combine sick and vacation. And in Colorado, you do get sick days. Yes, your employer has to give those to you, but those don't have to be paid out on termination. Those are, you use it, you don't use it. It's just there for you to take care of yourself when you need to take care of yourself. PTO, vacation, anything other than sick days, that is an earned wage. And in Colorado, even before, I think it was 2022, when they mandated it in statute, that it is an earned benefit. Before that, there was case law out there that said vacation is an earned benefit, and so you have to pay out on it. That's something that if your policy says use it or lose it, that's going to come back and bite you in the butt. If your policy actually is use it or lose it, that's opening you up for a lawsuit. So you need to separate those two for sure, and make sure that if you're giving vacation, that if you don't want them to continue to accrue it, then it stops accruing, or you pay out on it somehow, some way. My advice to people is If you've got 2 weeks vacation, they don't use it in a year, pay it out at the end of the year as a bonus and then start accruing again so that you never come to the point where somebody's worked for you for 10 years and now they've got 100 weeks of vacation. Yeah, that wouldn't happen, but anyway, you get the point. And then they
Yeah.
they say, please pay me out on all of this and I'm going to go start a shop and start competing with you. That happens. It's real. So that's one example of how an employee handbook can burn you. The other way is that in employee handbooks, if you're doing something to make it sound like you're guaranteeing employment is at will. And so you have to be really, really careful with everything that you're giving to an employee, not to kind of change those terms. And a lot of times people will come to me and they'll get an offer letter, which I love offer letters. And, here's everything that we're going to give you, but here's kind of what we're expecting. But I don't really want you to say, here's the contract. And a lot of times people will kind of change an offer letter and say, okay, here's the contract that we want you to work under and all the things we want you to do. When you kind of change it to contract, that kind of infers that it's not employment at will anymore.
Wow.
Be really careful with that.
Wow, that's amazing. It's interesting. I had a law firm call me that we are helping them with hiring and onboarding. They want to offboard or fire a long-term employee that's been there, right? And they had said, well, we're in the process of updating the handbook. To your point, it was about PTO in regards to it, and they wanted to update the handbook. They paid a big HR specialist create this, which was fantastic, but they wanted everybody to sign it. And then they were going to terminate their employee. I'm like, I'm not an employment lawyer, but I don't think that's a good idea. Thoughts?
Yeah, no. So kind of an interesting thing with that. Two thoughts. One, if you're getting people, and you should annually, if you're changing things, kind of get people to sign off on your changes to your policies and procedures, right? But one thing that you want to be careful about is, so like the non-disclosure agreements in Colorado used to be very, very broad, and now they're very narrow. And so if, for example, you had a non-disclosure agreement, non-compete agreement that was I'll have to go back and look at the dates just to be sure, but pre 2020, that's going to give you a lot more protection. And that's grandfathered in, so it protects the employer a lot better than what you can do today. And so for that, you want to be careful. And when you're saying, hey, sign the new, terms and conditions, with the exception of non-competes from 2020, and I need to check the date on exactly when that was, but you want to be able to maybe have a broader kind of non-compete, non-solicitation, whereas, current people that you're hiring now, they're going to be a lot more narrow on what you can do. So again, kind of to the example that you just brought up, Molly, if you've got somebody that was under another policy and you're about to terminate them and you want to terminate them under a new policy, not a good idea. You need to terminate them under old policy and move forward. And if there's ever kind of a question and you're like, as the employer, gee, I don't want to do that for the employee, it's much better to give a severance package, get a release, be a little bit more generous, because I guarantee you, if you're not, it's going to come back and haunt you. And the legal fees on that, and the way that, the employer has to, the burden of proof is really on the employer to prove that they did the right thing. The employee really gets a full ride, and everything's going to be viewed from the perspective that this employee was discriminated against, taken advantage of. And so it's really hard as an employer to win these kind of things. So be careful.
Yeah, I hear from people all the time. Well, Susie would never do that. She said, we've been together for what have you. It's like, well, Susie might not have that original idea or what have you, but we know we're going to hang up from this podcast right now, and probably I'm going to get articles served up to me about employee handbooks, about employment law, about what have you, the geo tracking that's out there, or Susie's at happy hour with her girlfriends and communicating that she just got terminated and she can't believe that, Danielle did this to her and blah, blah, blah. They're the victim, of course. And here comes the friends chirping, chirping, chirping in the ear, right? And you
For
hear
sure.
this all the time where you're like, oh, this would never happen to me. But in this day and age, do you see this more and more with the awareness that employees have that maybe they wouldn't have gone this route?
For sure. And something that I've always seen in practicing law is if the economy kind of starts tanking, that's when the lawsuits start going up and the claims start going up. And so people feel the pinch, and that's when they're a little bit more aggressive on pursuing things.
What are some other common, you mentioned PTO, sick time, being incredibly aware of your state. Now that Colorado, I always hear, is becoming the new California in regards to employment law. So often I'll see people that don't have a traditional HR department or what have you. So it's time to let Susie go, and we're paying out whatever the classification is, PTO, vacation, sick, whatever it might be. And now we're on a witch hunt, going through texts, going through emails in regards to time off. Do you have any tips and potential prevention strategies when it comes to requesting time off in alignment with the potential to pay that out?
That's a great question. You really need to have a good payroll processor and not do it yourself. So whether you're just paying yourself or not, you're taking self-employment taxes, whether you have employees, I would start with a good payroll processor. I love Patriot. I've done a bunch. It's easy to use. It's pretty affordable too. But that's important because you want to make sure your deductions are done right. But also with deductions for federal, for state, self-employment, those kind of things for the owner, picking up and making sure it's super tight. But they also do the sick time. They do the vacation. And so if you allow that third party provider to do it and your employee needs to kind of go through and deal with it, and especially too, Colorado now has the family medical leave, right? And
Yeah.
so days accrue for that, and things need to track, and they have to ask permission through the state, which is fortunate, right? And the state deals with it, so you as an employer don't really have to say yes, you can have the leave, or no, you can't. It's off your plate. But I would say the payroll provider for vacation and PTO, and just make sure that you've got it set up that vacation's separate and sick days are separate and they just track separately, because it is a pain to do it yourself. Could you? Yes, you could with Excel sheets and everything, but why? Because already taking out the right taxes and Social Security and all of that is pretty challenging. And so
Yeah.
if you have a payroll provider doing that anyway, then it's really easy to track sick and PTO.
That's amazing. Yeah, I could not agree more with that. And making sure you have it set up right, that they track it and the employee goes in there and enters a request and things of that nature. You brought up something that I have a question around. What is your recommendation around employee manuals? Meaning that most people will have someone sign it on day one, and then it goes in the proverbial closet on the shelf, what have you. And so often I will hear people, well, we have an employee manual and people are violating it. People are not following it. Do you have a best practice protocol or suggestion in regards to how to keep that alive and well from a protection perspective?
Sure. I've never had anyone ask that question, but that's a great one. And whenever you get an employer that's saying, hey, they're not following it, I love that the employer even knows what's there, because a lot of times they don't even know what's there. So if they're not following it, it's just great to, communicate that verbally to the team, but then follow up with violators and say, hey, you're not following this. It's important. Put it in writing, put it in the employee's file. Is it best to do that on a separate little letter memo to them to put in the file to save in a PDF? Yes, that's better, instead of in that random email or text or whatever. But if you're doing the random email and text, make sure it gets to the employee's file. You've got to have a lockdown secured employee's file and get those things in there when you're sending them. So good that you know that they're violating them, but put it in writing, document it, and put it in the file.
Okay, here is the controversial question. My last question for you that I hear about, especially when it comes to employee manual, and this may not shock you. dress code. So often I will get phone calls about inappropriate dress code, what have you, and how to handle, especially if it's a male female dynamic or it's kind of where it could cross over into many different areas. Do you have any suggestions in regards to either language around that or enforcement when it comes to dress code?
Sure. It's a tricky one for sure. And it really kind of depends on the company and what they really want to present, right? And so if a company really has a good idea of, we want everybody to wear a uniform. In construction, it's pretty easy because they like the company's polo shirts with the company brand on it. But then what are they wearing below the waist, right? That's what always kind of comes up. And it kind of depends on who are they interacting with, what are they doing. And for construction, there's also the safety piece and needing to be protected on the job site. And so, sometimes that's, boots and a hard hat and, long pants, right? No shorts. So, it kind of depends. And it can be different depending on what the employee is doing, right? And what's required. But you can certainly tailor in a handbook that we require certain things. And if it's pants or a skirt that's to the knees, you can certainly say that and require that. And something that's not transparent, that's opaque, you can require that too. So it just depends on what the employer is really wanting. And you can put that into a handbook. You can work with an attorney, but you can also, this is a great use of AI, for goodness sakes, right? You
Yeah.
can work those we're having challenges with Susie and she's wearing this. Our handbook says this. We're willing to do X, but how best to kind of communicate that to Susie that it's not, or to change what my dress code and what acceptable dress code is and work that through with AI. That's something that you certainly can do. You have to be obviously careful that you're not infringing on religion, right? And if
Mm.
somebody, for example, needs to cover their head for something, that's something you cannot, kind of dictate. But if it's just professional attire, you can define that professional attire the way you want to define it. And if you're seeing that it's being abused, just get a little more granular with how you're defining what professional is.
Yeah, I love that. Common things that I hear, like, for example, that you wear a shirt up to the neckline, that we wear blazers. Another thing, big thing, is the long fingernails with crazy coloring. And then when they're typing, it distracts the entire office, or the clients can hear it on the phone, or the big fake eyelashes. And so it's appropriate. Polished shoes are another thing that I hear about, and it's appropriate if I'm hearing you correctly. And one thing that I love when I help onboard new employees is that they'll have it really tied in with the branding of the firm. For example, I have a firm in South Florida that they are big, big, big. I'm wearing kind of the Tommy Bahama Hawaiian shirts and the shorts and boat dock shoes and things of that nature. And that's just part of the brand. They love dressing like that. Other ones that are incredibly traditional and want a blazer, what have you. So if you name it and tie it into the brand reputation of the firm, is that acceptable?
Absolutely.
Yeah, great. I love that. And I worked for an attorney that I love because every quarter we would dust off that employee manual and we would bring it up. And he was a male, and it was tricky for him, even way back 25 years ago, where sometimes he would just reiterate that and then allow for just naming of where we're maybe getting a little lazy, or I would use some really non-threatening terminology around that. And by and large, it was dress code. That was a big one that was consistently coming up. So every quarter, we would kind of go through the manual and a high level around what time we start. People are coming in late. That's another one I hear all the time, is late consistently, consistently, consistently.
One other one that popped up that was a little bit, kind of Colorado, right, is hygiene. And
Yeah.
yeah, so you can even, put something in the handbook And most people don't think about it until they've had somebody that hasn't been taking really good care of themselves and is starting to offend others around because of that. And so, that's something that you can work into. So there's a lot of gray area for sure, but there's definitely ways to address and deal with things.
I love that. So tell our listeners how they can follow you. We'll have all of your links, your website, your LinkedIn, all of that. And kind of what your ideal client looks like outside of the construction and contractor industry.
Absolutely. You can follow us on LinkedIn. You can follow us on Instagram. We are starting to build that. I don't personally, I should say, I don't love social media. I'm not somebody that spends a lot of time on it. I know it's important, but I've been able to build my practice on referrals and I love that. So I haven't had to lean too far into social media, but I think it's an important part. And I am starting now with Molly's help and a great assistant that she helped me locate and find that's been really great at kind of the operational side. But we've had a bunch of transition on my team. And so we're trying to get the backfill in. And then we're going to lean into the marketing because right now I couldn't take any more clients if I, had 10 of them knocking at my door.
Oh,
I'm just too full. So I need a few more good folks on my team. And I think I've got one with a paralegal, but I'm still looking for an associate that would like to join my team. So once we get that in place, then we'll start ramping up our social media. So apologize if you guys love social media and you wonder why I'm not so active. I just can't take any more business right now. So we're going to pump the brakes on the social, but would love to help you personally if you want to connect and set up a time for a call if you've got a question about what I do in my practice or how I might be able to help you in your practice. I always love helping other attorneys. And then, for clients, it's relationship. And if there's a really great small business person that you know of that's having an issue or needs some better guidance and they're in construction, would love to, put them on my wait list, but I'm not accepting new clients right at this moment, but soon.
oh my goodness. Well, we'll put all your links there. Congratulations. I mean, what attorney wouldn't want that problem, but you don't like saying no to business when it comes to growth and scaling. So we need to get you. For anyone listening in Colorado, what type of ideal attorney would be a good fit for your firm?
Somebody that would be a good fit for my firm is somebody that really wants to embrace technology and lean into kind of a new lean practice and is not tied into big law. I like to bill 2,000 hours a year. Quality of life is a little bit better. And, that's kind of the focus is that we want our whole team to have a better quality of life and be able to have a life outside of practicing law. But when we're practicing law, it's going to be exciting, dynamic.
Yeah.
We're going to put client service first and just continue to work with clients that we really love with a team that we love.
Oh, how wonderful. I love that. And would you want someone with litigation experience?
Yeah, great question, Molly. Thank you. I do want someone with litigation experience, even though I try to talk my clients out of litigating often,
Yeah.
almost daily. I usually run about 10 to 15 cases, and they're not big, crazy, complex cases. They're usually breach of contract, mechanics lien foreclosure, that type of a case. But I don't like litigating and I don't want to litigate anymore. So I kind of want somebody that's had some litigation experience. 5 to 15 years is kind of what I'm looking for to kind of take over and run the litigation docket, have good paralegal support. I'll be strategy, but I don't want to, do the day to day on, well, now we need to follow up with our client because they didn't get us the right document. And opposing counsel redacted the heck out of things. And now we need to do a discovery dispute letter and set a motion to compel. Just the day to day pushing it forward and constantly saying, I'm never done until I have the next appointment on the calendar when I'm going to follow
Mhm.
up for this last, just continuing to move it forward and say, we're not stopping until we've got a great result at the end. And we're going to keep pushing and driving for it. And then, giving transactional support as needed. And I would love to teach somebody really how to do all of the client counseling, the operational documents to tie those into the estate plan and, learn that piece of the business. But yeah. a little litigation experience is going to be great, because that's what I want you to really take over and take ownership of.
You need the skills, you need the knowledge, but you're always preparing for trial with the hopes that we don't make it there, right?
Absolutely.
Well, thank you, Danielle, for being our guest today. This was incredibly insightful and a necessary conversation that I know a lot of law firms are not aware of in regards to employee handbooks and really treating this incredibly seriously as we spoke about today. So thank you for being our guest. We'll have all your show notes here. We'll have all your links for people to stay in communication, to follow your journey. And as always, people, attorneys, get your people pieces in place. Start taking this seriously. I really highly recommend that you read Danielle's blog here, Lessons from the Legal Trenches. I think the top 5 areas you hit are so paramount. And even if you just focus on those pieces and areas of your practice, it is, what's the saying? An ounce of prevention is, I forget the rest of it.
A pound of something.
Yes. Another way to say this that I like to always say, if you don't make time for your wellness, you'll be forced to make time for your illness. And a litigation and employment case is a hell of a illness that I definitely do not want to find myself in that camp.
Absolutely. Thank you, Molly.
Thank you. All right, guys, until next time, continue being legal leaders, leading legal leaders.
I'm so tired of micromanaging. How do I train, manage, and lead? I can't find time to be visionary. Head down in the